Good day, I'm Jackie Judd. Beginning March 26th, the Supreme Court begins an extraordinary 3 days of hearings on the healthcare overhaul law, the Affordable Care Act. The central issues are the individual mandate requiring most Americans to obtain health insurance or pay financial penalties, and the expansion of Medicaid, and whether each is constitutional. Stuart Taylor, a contributing editor for the National Journal on Legal Matters, joins us today to dig deeper. Welcome, Stuart.
Nice to be with you.
Let's talk about the mandate first. When you've gone through the briefs, how has the federal government, how have the state governments tackled the constitutional questions raised by the mandate?
The fundamental question about the mandate is whether Congress has power at all under the United States Constitution to require people to buy health insurance or any other commercial product they don't want. Congress has never done this before, and so there's no clear precedent. But the government claims that it has ample power, A, to regulate interstate commerce, which has been broadly construed, and B, to lay and collect taxes, which has been even more broadly construed, and that each of those powers independently suffices to justify the individual mandate as a response to a national crisis in health insurance coverage, which clearly involves interstate commerce. The states, on the other hand, say no. The commerce power has never been interpreted that broadly, and if it's interpreted that broadly, the federal government's power will be without limit. Contrary to the intent of the framers, the federal government could require anybody to buy anything. That's not what the Constitution provides. On the taxing power, again, the government says we have power to do this because the taxing power is broad enough to encompass what was done here, because it's a penalty provision that's paid to the Internal Revenue Service if you don't buy the health insurance. The states say, hold on a minute. While this was pending in Congress, the president and other supporters said this is not a tax. They said that because they knew it would not have passed if the people had thought it was a tax. And they can't turn around now and say, guess what, it's a tax. For purposes of us defending its constitutionality. They say that would defeat accountability in government.
One of the lesser-known issues that will be discussed at the court hearing, but important, is the Anti-Injunction Act. What is the AIA, and how does it apply, or how may it apply to this argument?
This is one issue on which both opposing parties agree, but it gets complicated. The Anti-Injunction Act says the government, no court can enjoin a federal tax unless and until it's actually being collected, which in this case would not be until 2015 because the mandate doesn't take effect until 2014 and so forth. And so the argument would be, and the court will hear argument from an independent lawyer, the individual mandate litigation has to be deferred until 2015 because there's a law that says the court can't do anything about it because it's a tax.
And is there some possibility here that the justices could decide that these questions can't be answered until 2015?
That the individual mandate
Yes.
questions can't be answered. There is a possibility. I'd say most people would say it's not very likely, but frankly, if they want to duck, if it's a close call and they want to duck this in an election year, that would be a very convenient way to do it.
Now, the other issue still attached to the question over the mandate is severability. Whether the mandate can be judged separately or if it is so intrinsic to the overall law that the whole law either rises or falls on it.
Right.
What are the...
There's a range of, remember this is a 2,700-page law with dozens and dozens of provisions, and there's a range of answers to that question. Some say, neither of the parties in this case say, but some say the rest of the law should stand. Congress would have wanted it all to stand even if the mandate was gone. Mm-hmm. The federal government says, well, most of it should stand, but there are two big provisions, the ones that require insurers to take everybody regardless of pre-existing medical conditions and not to discriminate against people based on medical history in their premiums. Those would have to go down with the mandate, says the federal government, because it is the mandate that would provide the insurers with the money to pay the costs, the extra costs they would incur. The 26 states and their allies, on the other hand, argue that the mandate is an integral part of the law, that it all falls apart without the mandate, that the coalition that supported it would not have supported it without the mandate, and that therefore the whole law needs to go down. So the court has a huge range of options there.
And then on the issue of Medicaid, the expansion of Medicaid, how do the parties attack this issue in their briefs?
The states say that they are being, 26 states, not all states, that they are being coerced by this law to expand Medicaid beyond the point where they can afford it in the long run. The federal government would pay the costs of it in the short run, but the states would eventually have to pay more. And now they have traditionally voluntarily participated in Medicaid in exchange for the federal money. They say, well, this is different because we are now so dependent on Medicaid that we can't afford not to be in it, and this law requires us to pay more money or takes it all away from us. The federal government says that you can drop out of the Medicaid program if you don't want to keep participating in it, and therefore it's voluntary, and therefore you're not being compelled, and therefore it doesn't violate state sovereignty under the 10th Amendment.
Thank you so much, legal analyst Stuart Taylor.
Thank you.